The High Court stands as the apex judicial body within the state, holding the pivotal responsibility of interpreting the law, safeguarding fundamental rights, and ensuring the rule of law prevails across its jurisdiction. Established as a cornerstone of the single integrated judicial system envisioned by the Indian Constitution, the High Court serves as the highest judicial authority at both the state and union territory levels. This article aims to study in detail the High Court, including its history, constitutional provisions, composition, powers, jurisdiction, and other related aspects. About High Court. The High Court is the apex court in the judicial administration of a state under the integrated judicial system established by the Constitution of India. The High Courts have been envisaged as the highest court of appeal in the state, the guarantor of fundamental rights, the guardian of the Constitution of India, and the interpreter of the Constitution of India. About Indian judiciary. Inspired by the Government of India Act of 1935. The Indian Constitution has established a single integrated judicial system with a three-tier structure: the Supreme Court, the High Courts, the subordinate courts, district courts, and other lower courts. This single system of courts enforces both central and state laws across the country. Constitutional provisions related to High Courts. Articles 214 to 231 in Part 6 of the Indian Constitution deal with the provisions related to the High Courts. The constitutional provisions mentioned under these articles deal with the organization, independence, jurisdiction, powers, and procedures of the High Courts. The Parliament and state legislature both are authorized to regulate these provisions. Territorial jurisdiction of High Court. The Constitution of India provides for a High Court for each state. However, the 7th Constitutional Amendment Act of 1956 authorized the Parliament to establish a common High Court for 2 or more states or for 2 or more states and a union territory. For example, the union territories of Jammu and Kashmir and Ladakh have a common High Court. The territorial jurisdiction of a High Court is coterminous with the territory of a state. The territorial jurisdiction of a common High Court is coterminous with the territory of a state as well as a union territory. The Parliament can extend the jurisdiction of a High Court to any union territory or exclude the jurisdiction of a High Court from any union territory. Composition of judges of High Court. The Constitution does not specify the strength of a High Court and leaves it to the discretion of the President. Thus, every High Court consists of a Chief Justice and such other judges as determined by the President. The President determines the strength of a High Court from time to time depending upon the workload of the High Court. Appointment of judges of High Court. The Chief Justice and other judges of the High Court are appointed by the President of India, as can be seen in the following sections. Appointment of Chief Justice of High Court. The Chief Justice is appointed by the President after consultation with the Governor of the concerned state and the Chief Justice of India. Appointment of other judges of High Court. Other judges of the High Court are appointed by the President after consultation with the Governor of the state, the Chief Justice of India, and the Chief Justice of the concerned High Court. In the case of a common High Court for 2 or more states, the governors of all the states concerned are consulted by the President of India. As per the second judge's case, 1993, consultation with the Chief Justice of India means concurrence and advice tendered by the Chief Justice of India is binding on the President. As per the third judge's case, 1998, the Chief Justice of India should consult a collegium of the senior-most judges of the Supreme Court before recommending the name to the President.